Free legal advice, everyone. So I'll start while everyone's trickling in. I'll start by introducing the panel. I have Kevin Rupee from Wiley Rain, Mike Hazard from DLA Piper, and our friend Glenn Richards from Pillsbury. There are no lawyer jokes here to be made, except for the fact that between the three of them, we have about a century worth of legal experience that they're going to share. But
Glenn's side.
mostly on Glenn's side, maybe. But Glenn, for those who were in Las Vegas, actually had almost like a mic drop moment because the NPRM that we were talking about this morning came out 15 minutes before he went on stage, and he got to give us an update on what it really meant. So I'm going to start with giving Glenn the floor so he can give us a little click down, if you will, into what's happening and what to expect.
Great. Thank you, TJ. Thank you for inviting me back. Hopefully you won't regret that in about 30 minutes. And I'm glad that the FCC did us a favor and actually released the order on Friday. I don't want to rehash our speaker this morning, Tom, hit on some of the high points on what the robotext order did. But I think if there's a message that was sent, and my colleagues here hopefully would agree, that the time frame that it took from the release of the rulemaking to actually getting to an order in only 6 months, I think demonstrates the interest in the FCC in trying to stop what it perceives to be these malicious robotexts. So Tom talked about the types of blocking that the commission is now going to be requiring from the carriers. A few points that he didn't hit on that I think are important is this applies strictly to SMS and MMS and does not apply to over-the-top texting applications like WhatsApp or Facebook Messenger. I think that's a critical point. One of the questions that Tom was asked this morning was trying to make these distinctions, and the FCC is, I think, clearly struggling as to how it regulates some of these newer technologies that are internet-based versus the authority that it has with the mobile carrier. So one point that I wanted to make was this distinction. I think the other point that are a few points that what the FCC didn't do in the order that we were thinking they might. There's a concern from the texting parties that messages that were wrongfully blocked need to be unblocked. I think Tom mentioned that everyone has to provide a point of contact to receive those complaints. One thing that the texting parties wanted that the FCC did not address was a time frame by which those complaints have to be resolved, which probably will leave the texting community a little bit perturbed. The other thing that the FCC did not do was to require blocking notifications. So it's possible that for those of you that are in the ecosystem, you may or may not get notifications. I think the carriers had argued that those notifications were coming anyway, but the FCC specifically did not require blocking notifications once it did the blocking. I think a couple of other points that are important as to what the FCC may be doing. There's a rulemaking attached, and Tom mentioned that this order gets published in the Federal Register. There'll be comments that are filed 30 days after that, replies another 30 days. But one thing the FCC didn't do, which it's done in the voice space, which is require authentication. I think the industry did a good job of convincing at least the FCC to put a pause on that idea. But the rulemaking, once again, tees up the issue about how can we do text messaging authentication of those phone numbers. I think we heard a little bit about that on the prior panels. I think we're going to hear more about that in terms of trust. But the FCC has created this framework for the voice world called STIR/SHAKEN, and there are tokens attached, but basically every phone number needs to be verified in a sense that it belongs to a customer, that the carrier that originates that call knows who the customer is. They gave that phone number to the subscriber, and while you may or may not want to receive a call from that person, that phone number gets authenticated. And so that question has been teed up again in the rulemaking as to what, if anything, the FCC should do in terms of text messaging authentication. I think the other things that the FCC wants to address, and Tom hit on these as well, as to making it clear that if I've got a phone number that's in the do not call registry, that the text messaging folks need to be checking that and not texting me as well, making it clear that the DNC applies to both text and to voice calls. And I think that the concern, I think too, and one more very big issue potentially. So the FCC required that you don't block numbers. And I think there's some ambiguity around how you know what numbers not to block. We talk about unallocated numbers, invalid numbers, numbers to which the originating party tells you that they don't want to receive text messages or that text messages shouldn't be originated from. And it talks about this do not originate list, but it doesn't really provide a good framework or guidance on what that list will be, who will maintain those lists, how those lists will be updated. So I think with that background, I'll probably just take a stop. Folks may have questions. There's a lot of detail here. The order is dozens of pages. And to the extent that you've got specific use cases, probably worth talking to someone. I know that the three of us are going to be around all day today, but I think that, again, I think the point that I started with is the FCC cares about this. And I think the last thing we need, and I think Tom gave some good suggestions on how the industry should coalesce, and I think there needs to be more education. And I think if there was, even though the industry strongly opposed the rules that the FCC adopted, and it made some concessions to industry, I think ultimately the FCC said, we still think this is a problem. And I think maybe part of the problem was that the comments that attempted to distinguish the voice world from the messaging world, there wasn't enough education about the differences in those ecosystems. So I think if there's a to-do, and if folks are worried that the FCC may take steps that will make this industry even less profitable or less interesting to folks, I think that that's maybe one thing we can all think about doing, is educating, going up, talking to the FCC staff about the differences between voice and text. So with that, I'll take a stop and hand it back.
Well, that's a great way we'll have time for questions towards the end, but that's a great way to segue into, one thing that I was very clear about is that I think people don't fully comprehend is that the FCC is evenly split. So there is no Republican or Democrat majority, and yet you had all four commissioners said this is the way we're going to move forward. So it shows you the FCC is very focused on making a progress on this matter. But I'll move on to you, Mike. You have done a lot of work in advocacy in the FCC. What's your read on the situation?
Yep. So I take sort of an Occam's razor approach to this, which is the simplest answer is usually the correct one. So right, definitely 4-4 commission. If they're going to do anything, unanimously, that's a pretty strong signal. But also, there's a lot of pressure on them. Again, robocalls, number one complaint. Spam texting, number two complaint. But then I would also say is I'm not entirely sure, whether they actually really care that much about it. A lot of times the FCC can put something out there, get the ball rolling, and then they can tell people we're working on it. And so there are a lot of things that they've kind of pushed back to the industry, which I think is probably a good thing. But we'll see what they do over time. And then the last thing I would say is it's easiest for the FCC to but put the pressure on the carriers. If you get T-Mobile, AT&T, and Verizon, you can really shape the industry a lot. And then what they've done is they've given the mobile operators a very, very free hand to do whatever they need to do to block text messages or to mitigate what is perceived as an unsolicited message.
Yeah, and just to back up what Glenn and Mike have been saying, and what you teed off with, TJ, is whether it's robotext or robo-spams, or robocalls, this is an insanely bipartisan issue. And the thing I always point to is the passage of the TRACE Act in late 2019, passed through the House and the Senate, total, I think it was 4 dissenting votes. So like wrap your head around that Ted Cruz and Bernie Sanders were holding hands in agreement on this issue, right? And you see that at the commission. And, you know, to key off of something that Glenn hit on that is notable, we went from a rulemaking to an order in 6 months. And that is light speed at the FCC. And just to pile on top of that, we are now, with the release of the other order that Tom talked about, we're in our 6th rulemaking and our 6th order, all stemming from the Trace Act just 3 years ago. And that's just another indicator. I mean, there's been 6 rulemaking proceedings in the span of 3 years to do things like, you know, permissive blocking, mandate stir shaken, designate the industry traceback group, all these things. So it is, you know, a lot of activity and a lot of bipartisanship. But a lot of effort by industry as well, which is a theme that I think is really important for this group.
That's a great segue into the other question, which is you actually had the benefit, to paraphrase or what Tom said, to represent the dark side. You've flipped sides, you've represented a carrier. If you had to put your clients into buckets of, let's say, carriers, operators, CPaaS providers, A2P providers, what kind of advice are you giving them to make sense of what was, for me, was 1 NPR and became 6, and then suddenly there's 3, and it's an order, but not an order yet?
Right. So to that point, I think, you know, one thing that, like, I preach to industry as a whole is to fix this problem or fix these problems before they are fixed for you, right? And there are a lot of things, as Tom pointed out in his speech, you know, Stir Shaken was an industry-led initiative. The Traceback Group was an industry-led initiative. And those were things that industry did to sort of, you know, try to avoid regulation as best they can. But I think depending on where you sit, whether you're a carrier, CPaaS, whatever bucket you sit in, you know, number one, you need to be cognizant of what is happening at the FCC, what's happening in the enforcement space, and work. I think it's important to work within whatever industry frameworks you have available to you, whether that's a group like the MEF or Carrier Association, to engage with the regulating agencies. And I don't know if others have thoughts or...
I would just say, in my opinion, the number one most important reason to engage with the FCC is so that they know who you are and who your company is. It's pretty hard to actually really influence the process that much, but it's not that hard to know the people that are going to be writing the decision and to have them know you and your company. And there's been a lot of great talk about trust all day, and trust among networks is super important. But I would want to add the word confidence. And you want your colleagues at other companies to have confidence in you and in your company that you're going to follow through and try to make things better. And it's a huge opportunity here to get to know, if you're a carrier, to get to know the people in the aggregator space or with the CPaaS or vice versa. And one thing I've just seen TJ do, I've worked with TJ for over a decade, and he knows everybody. And so when he was, you know, with a private company, he could call up the people at the network operators and get problems worked out. As folks are talking about, a lot of this can be done by machines, but at some point, it falls out and there needs to be a human review of it. And if there's an issue and they say, well, let me call TJ up because that's the company he's at, and we can get this worked out in 5 minutes, I mean, that's a huge win for the company and for the industry. So I think kind of building those co-provider relationships is a really a great way to kind of level up all the work that people are doing on the trust side.
So the only thing I would add, and I'm not sure if it's a little bit of a dissent, is folks have mentioned, you know, engaging with trade associations. I've run for 25 years the Voice on the Net Coalition, small trade association, sort of focused on IP communications advocacy. I think the problem with some of the larger trade associations is, you know, the larger carriers and the larger members sometimes kind of obviously guide the advocacy, and I guess The question comes if you're not working for Verizon or AT&T or T-Mobile, whether their interests and the positions that they want to take in these things are always consistent with your interests. And I think that you need to be engaged, and I think sometimes people have a false sense of security that if they're a member of a trade association, that trade association will always protect their interests. But I think when you're dealing with companies that have their fingers in so many different parts of the ecosystem, that may not always be the case. So it's not enough to just write the check, but you need to participate on the regulatory calls. You need to review the pleadings when they're sent to you. You need to make sure that your company's interests and what you specifically do potentially are addressed, or at least that the pleadings are not actually doing something that would be harmful to your long-term interests.
So I'm going to make a declarative, perhaps controversial statement, which is the FCC has no jurisdiction over a CPaaS provider or over-the-top app. The only lever they have is to squeeze the carriers, right? And that perhaps guides their actions. Would you agree, disagree, or we modify that statement?
I mean, so again, pragmatically speaking, the FCC engages with the mobile network operators a lot on many, many different issues. They know them well. There are big teams on both sides, and the mobile network operators are very responsive to the FCC, and they don't want problems. They don't know the CPaaS providers as well. They don't know the aggregator community as well. So they're gonna, again, if you can take care of a huge portion of the industry by working on 3 or 4 companies, it's just easier, and they're always going to do what's easier. And it's just pragmatically speaking, if your company's text messages get blocked, no one complains to them. Maybe you do, but they've got 99 problems, and you're not cracking the top 100.
One like just to that point and related, you look at the FCC's gateway order, and I think we can all agree that the FCC's jurisdiction ends at the U.S. shoreline, right? The FCC cannot regulate.
So do you want to just give people
Foreign carriers.
An overview of the gateway order, just so that everyone?
Oh, I'm sorry. The gateway order was, I believe, the 3rd or 4th report and order released by the FCC. And what it essentially did, it said that domestic carriers that are intermediate providers, they don't originate traffic, they don't terminate traffic, but they accept foreign traffic from the Telefonicas of the world, the Telstras of the world, whoever. They accept that foreign traffic for termination in the United States. The FCC placed a number of obligations onto those gateway providers, regulatory obligations. But one of the interesting things that the FCC did is in that series of orders, if you're a foreign provider and you transit North American Numbering Plan resources, a gateway provider is prohibited from accepting your traffic if that foreign provider is not listed in the FCC's what's called robocall mitigation database. So it's a form of indirect regulation, and the FCC did get cute in a footnote saying, we're not telling foreign providers they have to register in the robocall mitigation database, but if they want their traffic to terminate, they will have an interest in doing so. So I think to Mike's point, it's just who do you regulate? You regulate carriers, and where are your choke points to get them?
But in the U.S. and elsewhere globally, that phone number is the hook.
Yeah.
And in the U.S., I mean, our phone numbers are just everywhere. Like all over the world, people are using U.S. phone numbers for all kinds of things. But the FCC is going to regulate the U.S. phone numbers heavily.
So I'm going to disagree a little bit with this. First of all, the FCC's hooks are licenses, which is how they continue to regulate the wireless carriers, and service classifications. And so I think it's a bit too broad or generalized to say they don't regulate CPaaS providers. It's like saying, well, the FCC doesn't regulate Google. Well, I can name 5 regulatory obligations that the FCC imposes on Google because they offer Google Voice because they offer advanced communication services which are subject to certain Disability Act requirements. I've been sort of dealing, Tom mentioned this morning that the FCC, during the Pai administration, classified text as information. That's what has made it difficult to now impose certain regulations on them. But to the extent, if you look at voice over IP, which started out as unregulated, they have over the last 20 years, basically, one step at a time imposed additional regulations on those services. If you're providing voice, you're providing telecom, and I'm not even sure I would even agree with the number. If you're providing certain types of classes of service, you are going to be subject to FCC and in some cases even potentially state regulations. So I don't think it's enough to say they don't regulate certain providers, they don't regulate Google, they don't regulate Apple. Well, no, to the extent those companies provide regulated services, they do regulate those services. It may be minimally for collection of universal service, it may be minimally for compliance with Disability Act requirements so people with disabilities can use those services. But I don't think it's enough to say, well, I do this, so I'm not regulated. I think it's a much more granular assessment of what you do and the services you provide and how they're provided before we can get to the question about whether you're regulated.
Yeah. No, I very great point. And to that point, when you look at the Trace Act, we have all been living in this legal regulatory world of common carriers and CLECs and wireless providers, et cetera. The Trace Act was a step in the direction of basically blowing those silos apart. It came up with this very broad definition of a provider of, quote, voice service. And to Glenn's point, that definition of voice service swept in, a whole host of entities and organizations that, to the extent they were providing voice service that fell into the Trace Act's scope, which is very broad, you're subject to the Trace Act. So, and the FCC's implementing regulations. So, it definitely agree.
So that brings, so the common carrier part, I'll use that as a segue into this other conversation. Mike and I did some work back in the day where thanks to today, pretty much every CPaaS has a common carrier-like exemption. Non-lawyer talking, I know there's a lot of asterisks to that statement. Mike, do you want to give a little summary on that? And what I would like to open it up to the panel is, what should the companies think about today? Common carrier for us was when law did not meet up the reality of the business. What are other points of conflict that are coming? Doesn't have to be necessarily with the NPRM, that we should be thinking of as an industry group, as tech innovators, to say, okay, we need to get in front of the regulators today so it doesn't become a problem a year or 2 years from now.
Yeah, I think Tom did a good job this morning about talking about just how old the statute is. And in some ways, it's even kind of more extreme than that. The real statute goes back, the original statute goes back to 1934, and then it's been amended a few times. And it just does not really adequately reflect the industry as it exists today. So there's Title II, which is the Common Carrier Services. And what's kind of interesting is that's where the TCPA is Title II. It's a Title II provision. Then you have Title I, which is sort of just like ancillary services. And it's kind of a generic kind of grab bag. So in some cases, like with VoIP, like Glenn was saying, the FCC put it in Title I, but then kind of layered on these Title II obligations. And then in other instances, they'll take a traditional Title II service and then take away common carrier obligations. So the long and the short of it is what the FCC has been sort of forced to do over time, because the statute is just kind of old and stale, is kind of use like duct tape and baling wire to fix problems as they come up. And we don't have a good unified system. I think what the risk over time is that the US system is no longer a leadership kind of system. If you look at Europe, you have the European Electronic Communications Code, which talks about like the conveyance of signals. And so it's a much more kind of forward-looking, broader-looking thing, and they have independent personal communication services and these much more kind of forward-looking classification systems than we have today. So I think what I would say the biggest risk we have in the U.S. is losing that kind of that leadership position over the way the world looks at the systems. And we've already lost that in privacy, right? GDPR is the global standard for privacy now. In California, they've largely adopted a GDPR-like system. So I think our economy and our nation benefits when we are the regulatory leaders. And a concern I have over time is that we are falling behind, and we have this very piecemeal system that, if you get a foreign company doing an acquisition in the U.S., they are just astounded by how strange it is, not only at the federal level with Team Telecom and CFIUS, but like, why does it take a year to get a license transferred in California? Like, it's inexplicable. But anyway, I'll turn it back.
Or Glenn, do you?
No.
Yeah, no.
Are there like specific issues like you think?
I think, I do think, at least in my world of particularly the voice space, I do think that any entity that is operating in any capacity in that space, there is an inherent need to stay on top of what is happening at these regulatory agencies. And I would emphasize at both the federal and state level at times, especially in California. Because the other terrifying thing about this from the company perspective, Mike talked about we're holding this regulatory structure in place with duct tape and baling wire, which is true. But what you're starting to see is this significant increase in enforcement. And that's at the state and federal level. So, companies have to walk this fine line between trying to stay in compliance with a regulatory framework that is unnecessarily complex and confusing, and potentially facing varying degrees of enforcement action. So over the last 2-3 years, the FCC's been firing off these cease and desist letters for companies that have originated robocall traffic, and that can have incredibly damaging effects on the company from both an operational and reputational perspective. So, you don't want to end up in that position, is sort of.
And the other thing I'd add is I think we've gone from sort of this deregulatory model, and I think it's a point Mike was making that the Europeans maybe have been better. But I mean, in a sort of the under the radar, something Congress did at the end of last year was they passed a bill giving the FCC more authority over inmate calling services. And while folks here might think, well, what's that about? Who cares? But in the context of prison communication services, they gave the FCC the first time the right to establish rates and regulate what we think of as video visitation. Video visitation, in my thinking, is Zoom calls. And frankly, if you go back 20 years ago to a decision the FCC issued, with that Jeff Pulver, they basically said that type of communication, information service, no one's regulating it. And if Jeff was here, he would basically say the reason you can have Zoom calls and video conferences for free is because nobody regulates it. Well, in this sort of camel's nose under the tent, again, in a very niche space in inmate communications, the FCC is now going to start rate-making proceedings to decide how much prison communications companies can charge for video visitation. And now you could just sort of see that as a steamroller that the states, California in particular, and others could say, well, maybe we can start regulating these services more broadly. And it adds ambiguity into the marketplace. So we went from this sort of market dynamic to where I think we're kind of backsliding in terms of the regulators regulating more.
Yeah.
Speaking of backsliding, and I know I do want to open it up for questions. We're going to talk about TCPA. We thought at the federal level, TCPA was a settled matter, and thanks to the Supreme Court order. And then there's a resurgence at the state level at the TCPA. And so I'll start with you, Kevin. And
yeah, Facebook to GWEED 2021. I guess the answer now is careful what you wish for, right? Because basically unanimous decision, 9-0 decision, and it narrowed significantly the scope of what an auto dialer is. And I remember at the time that the opinion was released, there was this tremendous hue and cry from, especially from the consumer sector about, the TCPA is dead. So what has been happening over the last few years is, in light of that, you're starting to see what are being billed as, quote, mini TCPAs. And to Glenn's point, you have all these states that are now stepping into the fray going, well, we're going to pass a TCPA statute that's going to broadly define, capture what an auto dialer is. And you're seeing these statutes. The most notable is in Florida, but Oklahoma, Washington have basically followed the Florida statute. It broadly defines auto dialer. It captures voice and text messaging. It has stringent criteria for express written consent. So the federal TCPA was never a model of clarity, to say the least. But what we're now seeing are these broader state statutes that are going into effect. And I've seen some studies showing that post-Degweed, you saw a decrease in federal TCPA litigation, but you've seen this massive spike. Florida, I think the number of state TCPA lawsuits increased by 400% or something. So, it's shifting from federal to state, and yet another headache that a lot of folks are going to have to deal with.
Mike?
Yeah, I think that's a good summary. And I would say at the federal level, I know that the FCC is just starting to talk about expanding text to do not call. I think that from an industry point of view, people have been doing that already just because the plaintiffs' lawyers have been so aggressive and the language is so similar. And then Florida is a super challenge. Again, you have a private right of action, and that's similar, $500 per call potential. I mean, they always settle cheaper than that. But there's a whole new rash of Florida suits now claiming that every number that sends a text message needs to be able to receive a voice call back. Now, if you read the literal language of the statute, it's amenable to that. But it's really talking about number spoofing in the voice context, but the state law is just written in a very awkward way. So there's literally dozens of these cases now pending that says the number you're texting from needs to be able to get a voice call back, and no one had operated like that to this point. So we'll see what happens there. But these are the kind of unintended consequences that we've been talking about.
And just to further add to the chaos, the Florida statute, the Oklahoma statute, there's multiple undefined terms in these statutes. So it's just...
Yeah, and then the plaintiff's lawyers will just iterate on them, right? And then they know, okay, maybe I won't get $1 million, but maybe they'll give me $50,000, and that keeps my lights on for a few months while I go do some other cases. So there's always that delta between some high per call potential versus what you'll settle for to kind of keep the game going in your smash and grab.
Yeah. We have time for a few questions. All the way back to Allison.
Hi, Allison Billings. Oh, I get a mic. This is a bad idea. Hi. So, really, really appreciate this. I think one thing, I've been doing this a long time. I know most people in the room. I spent some time at T-Mobile. I've bounced around a bunch of different places. I think one thing that's really unique that I don't think the regulators actually understand is that you made a remark about working at the dark side with the carriers, but I have to say, this is actually an ecosystem where there's a lot of cross-collaboration that you don't see in, I think, any other industry. And I actually think we've done a phenomenal job protecting consumers in a very rapidly changing environment around SMS and then MMS and these other areas that are developing, RCS, et cetera. My question is this. So as soon as we started talking, I really was curious about the declaratory ruling and the Title I stuff that came at the end of 2018, early 2019, and then these sort of encroachments that seem to come from Title II, right? How is that going to actually work out, or how do you see that actually working out? Because if Title II actually applies to SMS, consumers are going to be completely screwed. Like, this is all going to go away really quickly because we're all going to get just this deluge of information. Even if you're on Do Not Call, it's not going to change how you can curate the messages you're getting with consent, right? So that's sort of my question. Thank you.
I'm happy to jump on that. My first comment I want to make, you're right on the whole dark side. You know, I've been working in industry. I was at US Telecom. We started the Traceback Group. There is massive collaboration between wireline and wireless and cable and a host of others. And everybody I've ever worked with in this space genuinely wants to protect consumers. And I think they're doing a heck of a job of it. So kudos for raising that point. To your question, you know, one of the frustrating things of working with an agency like the FCC, and the classic example is net neutrality, you have these issues that are a ping pong ball. Like, you know, broadband is an information service. No, it's a Title II service. It's an information service. And it just goes back and forth and never ends. You know, what's concerning is I think there is a tendency, if we had a fifth commissioner, I think there's an open question as to whether, you know, we might be moving towards Title II for texting. But to your point, I tend to agree that its treatment as a Title I information service affords providers greater flexibility to do the things that need to be done to, you know, mitigate. So, you know, a lot of that is going to be driven by the administration and the priorities of the chairperson. But that's my 2 cents, and Mike and Glenn.
Yeah, Allison, I think it's a good question. My view is the FCC is not going to be constrained by Title I or Title II. It's going to keep putting things out there until it gets the result it needs, which is for the complaints to go down. And I think there is a recognition that, you know, there's a vast amount of communications that go on, and that's a tiny percentage that creates the problem, but it's a loud percentage. And I think Jeff Pulver's line is what, co-opetition is that the industry. So your competitor is your customer. So you know, we'll keep building on that.
I mean, yeah, I mean, I can't disagree with these guys. I think the leadership issue is important. I think, frankly, had the Biden administration's nominee been confirmed that has recently withdrawn, I would have probably laid 60-40 odds that we would have had broadband reclassified, VoIP classified as Title II, and messaging classified as Title II. I mean, I kind of feel very strongly that that would have been the result. I don't know who the Biden administration, if anyone at this point, is going to get, you know, fill that fifth position. But I think at this, you know, I think we're in a good place. But I agree with both these guys. I mean, until we stop getting those text messages that say "click here," that we all know are fraudulent. I know are fraudulent. Everyone in this room knows are fraudulent. But my wife's 80-something-year-old parents don't, right? They're clicking on those, and the numbers that we see in terms of the amount of fraud. And what may have been forgotten is the FCC didn't initiate this issue on its own. It was initiated because they were getting letters from Congress saying, what is going on here? We are getting these complaints. And an issue, I had even heard of the word robotext probably 3 years ago, right? And it was Congress basically saying, you need to do something. The FCC has done something. What I would be fearful of is if the FCC doesn't do more, and if Congress gets involved and we end up with a broader version of what what these guys have been talking about the Trace Act, focus, you don't want Congress looking at the text messaging space. That will be a mess. Worse than anything the FCC will ever do.
And just to hammer home what Glenn just said, I bumped into Brad last night from Call 'Em All. He and I were on a panel at the FTC in 2014 about what to do about robocalls. And I honestly, I was at a trade association, I said, this will be one and done. I'll just go talk to folks and then this problem goes away. 10 years later, we're in our 6th order in FMPRM. We've got congressional, you know, we have a new statute. So just staying with the theme, get ahead of this stuff as best you can. Because Glenn's right. Until the problem, and Mike, until the problem goes away, there's the specter of
And one more thing, if they
somebody fixing
reclassify it as Title II, it's then subject to universal service fees.
Oh, yeah.
So things like broadband that, are not taxed, we don't want to use the word tax, but it opens up the possibility of, a service that people perceive and the carriers have taken advantage of and doesn't really cost a lot of money to provide. Now, all of a sudden, they've got to allocate some piece of the dollars to it, and your costs are going to go up to provide those services.
Yeah.
We have time for one more question.
Hi,
Not Noah.
Hi, all. Noah Rafalco. You don't know me. So I had actually a few questions, but I'm just going to leave it at two light ones. Really, Glenn, you talked about, the unblocking, and as we know, the OEMs got involved, the handset manufacturers, with simplifying you to swipe. It first started with Android many years ago and then overwhelmed the FCC and FTC's kind of databases. And then Apple just recently had done it, which causes a lot of false positives. So when you say, there's going to be accessible people to unblock things, how many endpoints would a enterprise or a user have to actually touch at that point, considering you're talking about every person in the chain of custody that ends up blocking something because they see the word stop or quit. And then the second statement I wanted to make is toward you, Mike. You're never going to be left alone around me. So it really comes into, we've gone through some battles together at the FCC and TJ as well. And it really came into these broad strokes by just trusting the carriers. And it's not saying that they're bad people or bad organizations, but when you trust very few, they also make their own decisions internally what that means. And back in the day, they'd call everything spam, from a sermon being preached to a dentist appointment. So how do we actually protect ourselves and the consumers, because they won't even know a text isn't received if something's blocked, from code of conducts that are so vague at each of the carriers that allow them really carte blanche to do whatever they want as blocking?
So I think the first question was to me. I mean, on the voice side, it's been a problem, and frankly, it's getting worse. And I think STIR/SHAKEN in a lot of ways has actually made it worse. And I'm hearing now from some of the smaller service providers that we represent that when new phone numbers are put into the ecosystem for the first time by, that they're assigned, they're actually getting blocked because there's no analytics on them. And so all of a sudden, a new business opens and they've got a handful of numbers that haven't been in the stream before. So I think it's a problem. And I think that, at least US Telecom and the carriers have attempted on the voice side to create a mechanism by which people can complain about wrongfully blocked services. I think there's still a problem, probably both in texting and in voice, with misclassification, because we're getting, these false positives, to your point, spam likely. And spam likely may be attributed to a phone number or a message just because nobody's seen the phone number before. So I think you're right. The industry, to the extent it really wants to be cooperative, needs to work with the sending, calling, texting parties, that when those legitimate messages and calls are getting blocked, that they've created a mechanism by which people can get them quickly unblocked. The fact that the FCC didn't resolve in this NPRM how long that needs to happen doesn't send a great message that the carriers are going to really have the interest in getting things done timely when they're getting millions of these. And so, but you're right. I get the message from Verizon. It says junk, report as junk. I don't know what happens when I push that button, if anything. And I know that I still get the same message next week. So the flip side of what you're saying is, what are they doing with the ones that are clearly fraudulent, and who's taking care of that? So we have that balance that needs to be made.
No, I think that's really it. I mean, I do that too. You hope there's like a feedback loop, and that you hope that the provider that has the customer that's initiating the message is alerted to any problem customer that they have. But again, you can do all the regulatory stuff, and you can get in like arguments with people, or you can get in fights or litigation, and we've done all that. But what's more valuable and probably more difficult is developing that confidence in the others in the industry. And like, I would just encourage you, invest in your carrier relationships, invest in those teams, and get to know those people, and they try to win them over, get them to help you. If you're antagonistic to them, it's just not very effective. I mean, sometimes you have to do that. Sometimes there's no choice because you're not left with any other choice. But you're going to get a much better result if you can find a way to work with them. And David is like, when did Michael come around? But I learned it from you, Dad.
On that note, that's a great note. Thank you so much for our panel. Thank you.